Hi, good afternoon, everyone. This is Rajiv S. Khanna from the law offices of Rajiv S. Khanna PC. Today, I wanted to talk about the situations where transactional lawyers run into a problem that was not anticipated in routine proceedings. Non-routine proceedings, we always know. If the Department of Labor Wage and Hour Division is investigating or auditing our clients, we know what's going on. But even in those proceedings, sometimes in transactional proceedings like an H1 filing or an L1 filing or a visa interview, things can happen that if we had the sensitivity to understand that extraordinary things can come out of ordinary events, we would handle better. Okay, so the topic that I chose today to converse about was the G-Man Cometh, dealing with investigations and extraordinary consequences in ordinary audits, RFEs, and processing. While I'm talking about this, what I want to do is broadly discuss how agency investigations, audits, RFEs, and other types of processing, mostly in the benefits context, can give rise to these extraordinary issues by example. Things that I have seen happen, I have consulted upon, I have provided advice, our office has provided advice. So I will point out a lot of these examples and hopefully um, help everyone develop the sensitivity to when a proceeding already has or is about to step into an area which is beyond normal. What is the normal consequence of a benefits petition? It's a denial. Maximum they can say, the government can say, okay, your H1 is denied, or your L1 is denied, or your E1, E2, O1, EB1 is denied. That's a normal expectation. But there are consequences beyond that expectation, which is what we need to be sensitive to. I hope to remind us all about this highly technical and often counterintuitive nature of immigration law. And the most alarming trend in the last 8 years has been criminalization of civil conduct. That which was merely a civil or administrative violation has now been criminalized. I have helped in various defense teams, criminal defense teams in immigration corporate violations all over the country, almost from the all four regions: north, east, west, south. Um, and I've seen that more and more government is alleging and succeeding at least in um, letting criminal allegations in the civil context stand long enough to cost a lot of money. We might get them dismissed eventually, or we might not. So we have to be sensitive towards criminalization of civil conduct, which is another major problem in this area. You may find me once or twice repeating an example that I have talked about before. It's not senility. It is because um, there are various aspects that need to be covered arising out of the same set of circumstances. We're not going to talk about I-9 investigations. That is a whole big topic by itself. And I would very much appreciate a discourse, a discussion amongst us peers. You folks have any questions, comments, any war stories that we should all hear, that illustrate the points or bring out some of the dilemmas that you faced in your practice, please do share them. What I'm going to do is sort of the reverse of what we did in law schools, where you study 200 pages and the rule of law is only two sentences. I'm going to go with those two sentences first. So, therefore, the most important part of this discussion, at least in my mind, is the first 10 minutes. After that, I'm just talking about examples and how they play into those situations. So, therefore, if we are able to cover the first 10, 15, 20 minutes, after that, even if we spend the rest of the time just talking about our experiences and discussing them, that would be fine. I'll be happy to provide my input for whatever that is worth. Um, it's important to understand why you must know this. As I indicated earlier, that normal benefits applications and proceedings form the basis for a large number of these extraordinary audits and investigations. For example, an adjustment of status interview of an employee or a family-based beneficiary. I'm focusing more on employment-based cases, But the same principles uh, transpose over to family-based cases as well. A routine AOS interview, adjustment of status interview, could reveal things, or at least lead into things that would be extraordinary. So we've got to be aware of these matters. What are the non-ordinary consequences? What am I talking about? Well, we got to be careful. Clients can face expensive and protracted investigations. Many investigations go on for years. It is not beyond the realm of possibility for a Department of Labor wage and hour division investigation to go on into 1 to 3 years. It is very ordinary for a criminal investigation to go into 4, 5, 6 years. Um, of course, in a criminal investigation that's happening surreptitiously, we are not yet spending money, but we need to be aware that the consequences of what happened 5 years ago could show up 5 years later when charges are filed. I had a very interesting discussion with a very respected federal prosecutor, a very senior guy. He does a lot of the organized crime. And I had some questions for him as we go along, time permitting. I will point out some of those things that we discussed about. But what is relevant here is that I asked him, I said, how do you guys get around the fact that there are um, limitations prescribed to every offense? Most federal crimes carry a limitation, I think, of 5 years. That's what I understand from him. So there, the idea is the violations that are considered to be continuing can be prosecuted anytime within 5 years of the last act that we are complaining of. Clients can lose their business if these non-ordinary consequences are visited. For example, under federal acquisition regulations, which are applicable to federal contractors, and this is especially relevant to people who are practicing in the DC area. A lot of our clients are federal contractors. Under FAR, the Federal Acquisition Regulations, any federal contractor who is found guilty of immigration violations can be debarred from government contracting for X number of years. I think the period is between 1 and 3. It was a while back I looked at the FAR. But these are extraordinary consequences. Nobody's ready for this. Clients can be criminally prosecuted. Agency can invoke administrative mistrust and revisit all benefits already granted. So they find something wrong with one case, they can reopen 100 H1s, L1s, green cards, and start questioning every element of those filings. So it can be extremely expensive, extremely anxiety provoking, and maybe even unnecessary if we can plan for it a little bit better. One example is we have a client on an ongoing basis. They have had a lot of issues. Um, and the interesting thing is that the corporation that is under question is not a part of any criminal wrongdoing. But there are tie-ups with an organization that was found guilty. So that element of guilt has been transposed over to a totally separate corporation, and they have received notices of intent to revoke 2 or 3 times in every case. It's very odd. Okay, so we've got a notice of intent to revoke. We responded to it. I-140 was reinstated. They backed off. 6 months later, we get it again on slightly different grounds. So this administrative mistrust can be a real pain in the tuchus because it doesn't go away. It doesn't go away. The government can start questioning everything. Your experience letters, your employees' experience letters, um, you know, your company's corporate filings, successor and interest documentation, buyout proceedings. And in immigration law, piercing the corporate veil is relatively easy for the government, especially when they allege fraud. So if you think that your client is protected from personal liability, you might be in for a surprise. Then we have the legal malpractice concerns if we incorrectly approach or advise our clients. That's another serious issue. If we are not doing what a reasonably competent lawyer should or would have done in our circumstances, we are liable to our client. The good news is that the standard of care is ordinary competence. We don't have to be perfect in most jurisdictions. I don't think any jurisdiction would require us to be perfect. But we do have to defend a lawsuit, and that can become quite problematic. I wanted to point out the point number 6 on my presentation slide is government has a long memory. I am going to talk about a case, and this might come up a couple of times, about a denial of a naturalization 8 years after the alleged fraud. Okay, extraordinary consequence, non-ordinary consequence. What happened? Um, a privately held company, a 50 employees, not a large corporation. 8 or 9 years ago, while interviewing at the consulate for an H-1B, one of their documents, a letter from an end client, was deemed fraudulent because the end client claimed to not have signed that letter. Now, the end client was a very large corporation, thousands of employees. What happened there 8 years ago, we were not able to find out. Nevertheless, that individual's case, H-1B, was denied because it took so long. The H-1B petitioner, my client, our client, had no reason to go back and litigate that issue or agitate that issue too strongly. The project is gone. We don't need to hire this employee anymore. So they let it go. For 8 years, they did many cases, all H-1Bs, L-1s, green cards, never had any issue. 8 years later, the owners, the stockholders of the corporation apply for their naturalization. Their naturalization was denied based upon alleged fraud 8 years ago. How we handled that, how we went on from there, I'm definitely not going to call it success, but at least whatever we could do under the circumstances we did. But these kind of cases can also become a problem for your client's green card because after denying naturalization, the government could move on the green card, saying that because you have committed a fraud related to immigration, we are going to take away your green card and it's a permanent bar from entering the United States. So their lives could be uprooted. I think that's a non-ordinary consequence. There are concerns in mergers and acquisitions for pre-existing liability. Now, this is an ordinary proceeding, a merger and acquisition. There's nothing, extraordinary about it. But we have seen cases where I was defending a bunch of companies. One particular one sticks in my mind in the Department of Justice investigation for discrimination in employment. The company during the investigation got bought over. Okay. Now, in the Office of Special Counsel, who's responsible in the DOJ for these investigations, there are no particular specific regulations or policies that get into what to do if there is a takeover of the corporation. This is an ordinary merger and acquisition. If you did not know about this possible implication, you probably wouldn't cover it. Okay. So when the company that took over the earlier company was hauled up by Department of Justice again, saying we have this ongoing investigation, and you've bought this company. We are going to hold you responsible. And they say under Title VII, which is the discrimination provision, civil rights, etc., we are going to import principles from that jurisprudence over to this jurisprudence and hold the successor in interest responsible, even if you had no notice of this investigation. Well, again, this was a situation we were able to resolve relatively easily, but this is definitely something that would alarm me. In another merger and acquisition case, when I looked at the contract, the M&A contract, I very strongly advised our client who was buying this set of companies that they should put away some money in escrow for a few years, because you never know what kind of pre-existing liability there could be in immigration law. Fortunately, the client took our advice. They went ahead and put a few $100,000 in an escrow. That was the smart thing to do. 3 months, 4 months into this, we got 20 notices of intent to revoke for the company for their I-140s based upon fraud allegations. This I'm happy to report, we won every single one of these cases. There was no problem eventually, but it cost a lot of money. They were asking for extensive documentation. So when you are aware of these kind of things, even in ordinary proceedings like mergers and acquisitions, visa interviews, you want to make sure that the record is complete. Otherwise, these non-ordinary consequences can come and haunt us. The last point I wanted to make in this slide was that when we take over a representation from another client, from another lawyer, we've got to make sure the beginning and the end and the extent of our representation is properly defined. For example, if a client comes to me and says, well, we did our LCA already, can you take over the rest of the H1? I want a waiver from any liability that has happened and that came from the certification of that LCA, because I did not handle it. Our office didn't do it. We also want to make sure our retainers pinpoint the extent of our engagement and when our engagement is over. So we don't want a benefits application to continue forever. Okay, so all these are, non-ordinary consequences that occur both for clients as well as for lawyers while we are in the middle of ordinary proceedings. My entire over 2 decades of practice of law, of immigration law, I've worked in many other fields of the law. I have seen some things, these points, that 7, 8 points that I have on this slide, as being the bottom line of good practice. And again, I welcome your input. If you have any comments or questions, I'll be happy to talk about that. First of all, prepare every filing and RFE response with investigation in mind. Think that you're going to get investigated. So if somebody calls me and says, XYZ was the officer before this, ABC is the next officer, can they sign on behalf of this person? I want to be very sure that indeed this is a uniform practice. This is not something which is non-ordinary even in the clients. I mean, there's a limit to how far you can go in investigating clients' own processes, but there is a certain amount of responsibility. One example I'll give you is when we prepare PERM applications. I want to know what the standard job description is, not what is being prepared for this particular employee, but what is the standard job description? And if there's a variation from that job description and requirements, why is that there? Because I'm thinking, what if Department of Labor comes and says, we want to see all your filings. Here you have a filing for RF engineer where you've required master's plus 3 years, another one you required master's plus 10 years. What is the reason for this? We should be prepared for that beforehand. Another very important point is prepare the record for litigation. It is extremely important. There are many cases which I have prepared knowing fully well that I'm going to lose both before USCIS and before AAO, but I want to prepare the case for a litigation, for a mandamus or an injunction or whatever the cause of action may be, but I'm not preparing the record for winning before the government. I think I'm going to lose there, but I want to prepare a strong case for litigation. Why is that important? Because when the case goes before a judge, normally, there are extraordinary circumstances where you might be able to, but normally they are not going to let me supplement the record. Whatever was before the government agency is what the case will be decided on. Okay, I had a very interesting case a few years ago where two physicians, one physician was on H1, I think, here in the United States, and his wife, also a physician, came to visit, and They wanted to extend the tourist visa. They went ahead and sent a letter to USCIS, no forms, saying, we would like to extend her stay in the United States. Can you please, provide the extension documents, whatever we need to do? And this was a good 8 years ago, 9 years ago. The government, of course, never responded. Next thing is she stayed on thinking that she's in status because she sent out that letter. I don't know why they did that, but whatever the reason was, um, they went ahead and did that. Next thing is she was subject to 3-year bar, having overstayed by 180 days. They came to me very concerned. We ended up suing the government over this. And the only reason the judge was very chagrined with USCIS was because they did not respond to that one letter. They said, we don't care how big an organization you are. If somebody's asking you what to do about this and they are assuming that you're going to respond if something needs to be done more than the letter, you should respond. I'm not saying that this will happen in every case, but that was a rather extraordinary case. The government did back off. We got status nunc pro tunc, and we were able to escape the 3-year bar. Uh, so, this is an example of a minor document that can become instrumental in winning a case. I also like to give reasons for withdrawing whenever I withdraw a case. So if I withdraw an H-1B, I like to give a reason. The employee is no longer working with us, or we've lost the project. Whatever the reason is, why? Because the record is then complete. The anti-fraud people, when they review the files, from the files they should be able to tell what the case is. Sometimes we have filed motions to reopen just to supplement and complete the record, knowing fully well we are not going to win the MTR. American Immigration Lawyers Association, most of you here are members of AILA. AILA has excellent material on how to deal with visitors. If somebody, like a government officer, comes and says, look, I'm from the Department of Labor, I want to take a look at your files. Or a member of public comes and says, I want to look at your public disclosure file, how to deal with that. I'm not going to get too much into that, but be aware of that. That material is there on the AILA website. Very, very important, point number 5. If you get forewarned that we are going to get into murky criminal waters, I think it's very important to get criminal defense counsel involved as early as possible. Some of you, I know, do practice both criminal defense as well as immigration law. Great, you guys can handle it. Now, our firm has, for the last almost 3 decades, worked only with difficult immigration cases, business and employment-based cases, investment cases. We don't do any criminal defense work except as um, um, consulting lawyers to criminal defense teams or experts in criminal defense for immigration matters. It's a good idea to have conclusion of representation letters sent at the end of every case, because you want clients to know, look, I no longer represent you. So if somebody's come for an investigation on a case that we got approved, it doesn't mean that I have an ongoing responsibility to be there. If I'm too busy somewhere else, I might not be able to take the representation. And point number 7, another important point, be nice to the investigators, but not too nice. Why is that important? I think I talk about that a little bit further down as well. Investigators have unique powers in that they investigate, they recommend whether this matter is going to go further or not, and they also help decide penalties in most cases. Okay, so I want to be nice to them. I don't want to, be adversarial unnecessarily. But if an investigator is out of line, I do want to um, exercise my rights. I do want to step in and say, wait a minute, you're out of line. I am not going to provide you this documentation, or I'm not going to let you browbeat my client to this extent. Sorry, you need to back off. So we need to have that sense when we are being too nice. The general rules that I follow for all audits and investigation. First thing I want to find out is who is auditing and investigating, if the investigation actually starts. And the reason I'm doing this is, even within audits and investigations, there can be extraordinary consequences that we want to be aware of. Okay, how to distinguish between routine and non-routine proceeding? I assume all investigations are non-routine until proven otherwise. We had a case in which I was on the spot. Normally, we just attend by telephone these investigations because we have a national practice clients in every major city in this country, um, as do a lot of you. So it's not possible for us to be there in every investigation, nor is it necessary in most cases. But in this particular case, this was in Maryland. A team of 5 or 6 people show up saying that we are an I-9 audit team. Now that immediately um, alerted me. There's so many people for a, you know, 60, 70 employee company, or was it even smaller than that? That didn't make any sense. So when I asked for their business cards, 3 of these people did give me their business cards, and 2 of them just said that, oh, we are with the team. I made an issue of it. I said, no, I need to know who you are, or you need to step out. Okay. So when they finally very grudgingly produced their cards, they were FBI agents. Immediately, I said, sorry, this investigation cannot go forth. You have to wait until our criminal defense counsel shows up. And that turned out to be a very good idea. The moment the criminal defense counsel came up, he was himself an ex prosecutor, federal prosecutor, very assertive, very smart man. Came in, he says, everybody out. Everybody out. He asked everybody to step out, all the agents, all the investigators. And, he basically said, every communication will go through us, tell us what you need. So he refused to have the clients talk directly with any of the investigators. So that assumption that this is a non-routine was a good idea. Another thing you need to know about is that there is a lot of interagency cooperation these days. They have all these contracts, these agreements between agencies that if we find this out, we will report it to you. So many wage and hour division investigations are triggered by complaints from or reports from USCIS or um, um, from the consulates. Things that emerge during interviews or during benefits filings get reported back, and next thing is you've got a WHD audit going on. As I was saying, have litigators' knowledge, but do not have the litigator's attitude. Be nice, but not too nice. So we need to know what litigators know. At some point, we can say, we're not going to answer these questions. But we cannot have that adversarial attitude. Investigators are fact finders, they are judges, and or the path to execution rolled into one. Okay, and some of these investigations are horrendous. I'll give you an example of WHD investigations, and I've done a couple of hundred of these, all combined. In wage and hour division investigations, if you lose before the investigator, let's say you got fined and some whatever the consequences have been visited upon you, and you end up appealing it, it's very important you understand what the appeal means, because the appeal before the administrative law judge essentially reopens the whole proceeding. You could end up much worse than you were before. On top of that, instead of dealing with a non-lawyer investigator who started the investigation, now you'll be dealing with the US Department of Labor's solicitor's office, which of course comprises litigators, and these people do this for a living. I have seen the solicitors come up with discovery requests in appeals that are so onerous that I think even federal courts would disallow them. However, a lot of times ALJs let them slide. Okay. So when you go into an appeal, even that, you have to have the litigator's knowledge, but not the attitude. Don't think that you can protect your client from some of these consequences. Be careful. Some of these cases, of course, are worth litigating further. Some of these cases may not be. To make things more complicated, the procedures evolve continually, and they vary from region to region. The agencies in California might be doing one thing, and they might be doing something totally different in Washington, D.C. Okay. Um, we need to know when to cooperate, how far to cooperate. It's a good idea to cooperate, especially when you have nothing to hide. Cooperation can reduce your penalties if there are violations. If I go in and I find something is missing in the LCA documentation, I will tell the employer, okay, your investigator is coming. Please go ahead and prepare this documentation, put it in, but put it in today's date. Don't backdate them because that would be, in my view, misrepresentation. The fact that we voluntarily stepped forward and we corrected the deficiencies in our own record goes a long ways. And I think it does help reduce your penalties. But then you also need to know when not to cooperate because non-cooperation can prevent unnecessary exposure. We had a case in Chicago. The Department of Labor WHD investigator said, provide me all emails that were exchanged between X and Y during this time. And I said, no, I'm not going to do that because there are privacy concerns. Next thing is I end up giving it to you without a subpoena and my client gets sued for all kinds of violations under the state law as well as federal law. So if you want this information, produce a subpoena. If it's a coercive process, I will produce it, even though there could be some argument that there is some duty to even try to quash subpoenas. But this is definitely better than just voluntarily producing it. So there comes a time where you've got to say, you know what, I'm not giving you this information. Point number 8, there's some repetition here. Know when to seek criminal defense. As I said, there was a combined force of USCIS, ICE, and FBI for that purportedly I-9 investigation. It's not just, it's just not an I-9 investigation. It was more than that. Okay. And also be mindful, item number 9 on this slide, whistleblower protections. If somebody, if one of your client comes to you and says, you know what, this guy has complained against me, this employee of mine, can I fire him? Be careful. There may be some whistleblower protection under the laws which you cannot violate. Okay. Now we are going to get into some of the more concrete examples, things that happen all the time in transactional matters. In the H1L1 context, one of the most contentious area has been end client letters, what their format should be, are they needed, etc., since the advent of that infamous memorandum, which was actually challenged in court, and the challenge was defeated. Um, the lack of end client has now become a criminally chargeable offense, and I have seen it in no less than 3 indictments. Company files an H1 without a specific project in hand. And next thing is, when the company is indicted, one of the counts says that they have filed H1s without a specific project. Since when did that become a criminal offense? I do not know. But it is important for our clients to understand that if you don't have an end client in mind and a specific project in mind, you should not be filing an H1 or an L1B where the employee, or even an L1A where the employee is going to work at a client site, okay, purportedly. Even for in-house projects, unless the project is well defined, with all the details, how many man hours it's going to take to complete, what is the project about, was there a market study done if you're producing software. They want all these details. And there's a pattern that USCIS looks at very carefully. When some employer hires an employee for an in-house project and then 7 months later places them at an end client and asks for an H1B amendment, USCIS looks at that very suspiciously, as though the in-house project was a pretext for the ultimate placement. Okay. So whenever I see a client who says to me, Rajiv, we are going to do an in-house project. I want to know all these details. And I make it clear to them, guys, listen, we can do it as long as we have a genuine good faith in-house project. And we can, of course, also place the employee at an end client site as long as whatever we are doing is in good faith. So let's say you've hired an employee to work in-house and they're developing something for you. Next thing is you can find a client with very good rates for this employee who's willing to pay you a lot of money in consulting. It's okay to use that and send the employee out as long as we have a genuine good faith reason. Okay. And we have somebody else doing that employee's work while he's gone working at the client project. And of course, you have to do an H-1B amendment. We have seen cases where unsigned end client letters were called into question as fraudulent instead of just being unsigned, which they were. It can happen. Our office can make a mistake and client can make a mistake. They are unsigned, all of a sudden they become fraud. You cannot let it slide. You cannot let it slide. If they say fraud, you've got to become very, very alert right away. Unfortunately, fraud in the benefits context is very poorly defined. Even in a normal civil litigation, when we say fraud, we have to plead fraud with specificity. We can't just say fraud. Okay, there's got to be a standard higher than preponderance, clear and convincing for fraud cases, but not so in the benefits context. Government very casually tosses out fraud. Next thing is people are suffering, your clients are suffering, they have all kinds of problems because of this very casual observation. So looks like an innocuous thing. Well, the client and client forgot to sign the letter. The moment they toss out fraud on that, be careful. You need to resist that vigorously. We need to make sure the record is complete. We need to make sure that government understands what the circumstances were. Provide affidavits, provide letters, provide evidence that clearly shows this was a mistake. We had a case recently in which this word fraud was tossed out. What happened was, typically we prepare the letters for the end clients. I don't see anything wrong with that. Um, and we will say on the letter that we send to the end client through our client, or if we are representing the end client, even then we would prepare that letter for their contractors. Um, and the letter will say very clearly, okay, here is what we think you should say if it is factually true. Anything that's factually not true, please change it. The letter must be factually complete and truthful. So, in other words, this is not a final product. This is a draft based upon which the end client should change things to comport with the facts. This was a case some other lawyers had done, and we were called in when that fraud thing developed. Basically, the lawyers send out such a form letter, which we do too, but the end client did not remove that note from top of the letter that says, Mr. End Client, here is a draft of the letter that you should provide. Please change the elements that are not comporting strictly with the truth. They did not take out that part. Government said this is fraud. Now I don't see how that is fraud. Okay, of course we resisted it very vigorously, and we did end up getting an approval on the case. Um, but it's a very odd situation where very normal, ordinary civil matters all of a sudden can become matters of great consequence. We have cases where employers have been hauled in for fraudulent degrees and experience letters provided by employees, and vice versa. Employee can also get into trouble because the employer falsified his resume. See, falsifying a resume for a job application, hyperbole is expected. But when you send a resume in the context of immigration law, as an H1 appendix or as an L1 appendix, that becomes a totally different matter. Now you are representing something to the government which is a hyperbole or which is untrue. Gotta be careful with that. In the green card palm context, what I have seen so far, and I would love to hear your experiences, of course, taking prohibited payments from employees. This practice, even lawyers I have seen who have not asked the client to step away from this practice, and that puts us in a very odd situation because the client will say, well, our lawyers told us it's okay to deduct money from the salary for all the perm expenses. And of course, our job is to protect the client. So what do you do? And this becomes very, very complex matter. Um, and again, time permitting, I would like to talk about the matter of Lozada and the implications of lawyers misadvising their clients and how you can protect your clients when such misadvice has occurred. We don't have to be perfect, but we have to be diligent at least. So we have seen cases where prohibited payments were taken. Of course, the moment we stepped in, we made the employer return those payments and put nothing but a memo in the file saying that this happened, and even sent a letter out to the Department of Labor saying this was done in error, and as soon as this error was discovered, we have corrected it. No consequences came of it. But it's important for us to do that. Another case we had in which the CEO of a fairly large company, I think there are about 400, 500 people, CEO was filing a perm for his own brother. But the lawyers, when they filed ETA 9089, did not check mark that box that asks you, is the employee related to a stockholder, officer, etc., of a corporation? And of course they were. Um, this thing was caught at the I-140 stage. And this is a relatively recent case. I told the employer, I said, there's no way we are going to win this case. But it is very, very important for us to complete the record. We want to make sure that there are no implications that you did this willfully. Okay, so this was a fairly lengthy brief we prepared. We actually sat down with the employer, with the lawyers, everybody, and we prepared detailed discussion of how this mistake happened to occur. One of the reasons it happened to occur was that when the lawyers sent their questions, there was no question about relationship. Even though ETA 9089 has that question, lawyer's questionnaire did not have it. So this was a genuine mistake made both from the law firm as well as the employer. But here's the problem. In denying the case, which we expected, USCIS observed, they said, listen, look at the ETA 9089. It says, I'm signing this form and I have read and understood the contents of 9089. So the fact that your client is a busy officer and he signs 1,000 papers a day and he often doesn't read them has nothing to do with liability, because he signed something that says, I've read this thing, I've understood the application, and under penalty of perjury, this is true. Okay, so that would have become a very problematic matter had we let it slide. Fortunately, um, because of the extensive documentation, the government, by the way, did not back off the fraud finding, but we've never had any adverse consequence from that fraud finding. We are willing to litigate it. Of course, if the government created an issue out of that even 8 years down the line, we would be able to litigate it because the record is now complete. And that's the importance. That's why uh, creating a complete record becomes very important. Supervised recruitments in perm are very, very important. We've got to be careful if we try to withdraw and walk away from supervised recruitments. Not only do the regulations provide their penalties, including making all the employers' cases as supervised recruitment cases, there are other implications such as abuse of the system. And the moment you have an abuse of the system, again, time permitting, I would like to talk about this in greater detail. Um, the Inspector General of an agency steps in. IG's investigations tend to be a lot more rigorous because IG, for example, if the IG of the Department of Labor stepped in, they would be looking at abuse of the system, not just one particular case. Okay, so if you have supervised recruitments that are being misused, um, you can have an IG investigation triggered from that. During visa stamping, remember the case I was talking about earlier where a citizenship naturalization was denied 8 years down the line. A similar case, um, actually, corporate fraud. Okay, this one I already talked about. I don't have anything else to add to it. Another case which happened recently. Um, we have we were asked to provide an opinion in a case where an employee was denied a visa without explanation. All they said was, you are found ineligible to receive this visa, and oh, by the way, you are also subject to 212A, the fraud ground, without giving any details about what fraud he's supposed to have committed. This was an H-1B interview. Okay. Now, our first problem is finding out what is this fraud. Government just says fraud without giving us any specifics. We have no idea what they are talking about. The client has no idea what they are talking about. Okay. Now, of course, the client was of the opinion, well, I don't really have to fight this out. I have another H-1B approval, and the consular officer gave me a 212D3 waiver for this. I said, wait a minute. A 212D waiver does not take away your permanent ineligibility to enter the United States. You can never get a green card. You've got to fight this fraud finding. There's something wrong here. So we're actually in the middle of that right now. We've sent out a Freedom of Information Act request. Some documents have been discovered, some others not. And it appears there's something that went wrong at one of his entries into the United States. The fraud finding was made by CBP, and that was found to be the basis of a visa denial, because fraud, of course, as you know, is a permanent bar. So sometimes these, again, seemingly innocent denial, oh, it's a fraud denial, I have another approval, they've given me a waiver, I can go forward. No, you really cannot. You've got to take care of that. It's almost like those Mario Brothers games where if you don't kill monsters at one level, they'll come back redoubled at the next level and get you. Okay. The KCC site visits, the Kentucky Consular Center has an investigation branch, relatively recent. I haven't known them to be very active, but a few years ago they were very, very active. And I always tell clients, if it's a visit from KCC, treat it as extraordinary, because they don't usually go out of their office for routine investigation. Like USCIS will send out people or even contractors verifying the particulars of an H1 filing. KCC doesn't do that. At least I haven't seen it. And in one particular case, when KCC came, I was advised by a client later on that they were very rude. Of course, we took steps to address that, because no investigator should ever be rude to anyone. They're public servants, just like we are officers of the court. They are public servants, and there's a limit to which I will let them. We all should let them go. Beyond a certain point of time, beyond a certain point of rules of civility, we've got to just put our foot down. But of course, keeping in mind there are consequences. Okay, both for them and for us. Um, a very fashionable set of investigations in the last 4 or 5 years have been school investigations. I don't know how many of you are aware of Tri-Valley University, which was the first major school investigation that I'm aware of. We talked with, personally, I think about 600 students, 600 students during the course of this investigation. Many, many students lost their careers, status, a lot of money. Again, depends upon which side you're representing. The school, in many of these cases, have approached us to represent them against ICE and USCIS, but we almost always have to decline because we represent students. Even if we are representing pro bono, we have to pick sides. We can't be on both sides. There are, when we represent these students, and again, these are ordinary investigations, maybe a little bit off topic, um, and maybe these are not really employer related, but we've seen status, unlawful presence, CPT being issued in the first semester, all of these become major issues somewhere along the line. Um, when does the status expire? Is it on the date ICE closes the school, or is it a 60-day grace period? All up in the air. They don't have constant uniform policies in this. When does unlawful presence trigger? Um, CPT in the first semester, like I said, is a big issue. Can it hurt your employer client? Um, it should not, as long as they are not willingly involved in it. But we need to be sensitive to all of these issues. In family-based cases, I'm gonna touch them briefly because they're really not a part of my discussion, but I want to touch them anyway. Um, we had we have a couple of cases actually where adjustment of status was applied after an entry into the United States using a B visa, and the government has made a fraud case out of it. Another case, ordinary proceeding, but the applicants believed that their marriage, religious marriage, was not recognized under US law, so they could apply for a fiancé visa. And their lawyer actually told them, who happened to be a Sikh gentleman, he said, under the Sikh Marriage Act, which is an unmarriage act, unless the marriage is registered, it is not recognized. And when we looked at the law and we consulted Indian lawyers, that turned out to be not true. So simple things, small matters, but next thing is the client gets hauled up for um, immigration fraud, and it's very difficult to get a waiver unless there are extremely exceptional circumstances. Proxy marriages has been another problem area. Um, in Muslim marriages, you can marry on the telephone in the presence of witnesses on both sides, but US government doesn't recognize that. I have seen issues arise from those cases. My conclusion to this discussion would be, just be alert for consequences. Because once there's a fraud or persistent bad business practices discovered by the government, they can really make things very, very difficult. And we have, I mean, they have put, I've seen them put companies out of business with their constant pestering, constant bickering over every small thing. So we need to be alert for consequences of even simple, seemingly inconsequential proceedings. Talking about the basis of audits and investigations, and all these slides I had put in so that I'll be able to discuss them if we have time. I've got about 15-20 minutes more. Let me see how much material I can cover. But the most important things were the first 15-20 minutes, where I laid out my entire um, conclusions in this area of practice. Complaints from employees are a very, very common reason for Department of Labor wage and hour division investigations. When, so what does that mean? So that means an ordinary proceeding, such as deducting money from somebody's salary, such as firing an employee, could have consequences beyond the ordinary. When you are involved with advising, if a client calls you and says, this employee is complaining about overtime or whatever, it's just not a matter of overtime. It could have immigration law consequences, and some of them are quite serious. There can be debarment, interagency cooperation, like I said, agency complaints. Now, here is a bullet point that I think is very important: publicly available information. This is relatively new. With the advent of social media, Facebook, LinkedIn, um, Pinterest, all these public sites, the government can glean information. For example, the employee is supposed to be, the title is supposed to be, let's say, take an example, project manager. But on the website, either the employer's own website or their forum discussions, or in the case of Facebook or LinkedIn media, the title is reflected as vice president, that can become a basis for investigation, especially if there is a pattern of these kind of uh, variances. Okay, we had a case in which we host our firm, immigration.com. We host a forum available to the public. A few years ago, I received a phone call from the FBI. We don't interfere in those forums. They're public forums. We don't maintain them. We just provided the space. So they are like a public discussion area. Anybody can post pretty much anything. And we only intervene when somebody is either defaming somebody else, like another law firm. We don't have to under, what is it, Electronic Frontiers Act, one of those acts where if we are merely maintaining the boards, we are not responsible for any of the content. We don't have to, but as a matter of courtesy, I don't want somebody bad mouthing an employer or another lawyer when they don't have a forum to defend themselves. So the FBI agent says to me, I need more information about this particular user. Now that puts us, it's an ordinary request in some ways because FBI is conducting an investigation and we should cooperate. But I felt that was unnecessary. And we had a similar case where another employer had a discussion board for kind of an extranet for outside clients as well as inside staff members. Similar situation. The FBI agent calls and I said, you know what? We're not going to surrender any information. Give us a subpoena. Unless you give us a subpoena, it's an ordinary request, I agree. But if we start surrendering information about people who visit forums or people who visit our clients' discussion groups, we are perhaps taking it too far. We are opening ourselves to litigation. It could be argued that the visitors or people who posted comments had some expectation of privacy. Our forums have disclaimers. Your clients should also have disclaimers. What does this have to do with immigration? To the extent that people are posting information about immigration violations. The particular information on our clients' and clients' website had to do with immigration violations. Okay, so we've got to be careful even in what kind of public information is being put out there. It has to be consistent internally as well as with immigration documentation. If somebody is a project manager, they cannot be shown as a vice president. I know that we are sometimes hyping people's titles up, but you shouldn't do that. One of the topics that comes to mind as I go along, I'll come back to it. In a recent case, Department of Labor, in an investigation, I thought that was highly unfair, but it creates some very, very odd issues for a lawyer. Department of Labor, Wage and Hour Division, in an investigation, went and talked with every employee that they wanted to speak with, 15, 20, 30 employees. Now here's one problem. I'm a lawyer. Who do I represent? Do I represent the employee? Do I represent the corporation? Do I represent the individual officer? Who do I represent? I need to know whom I represent in order to know when there is a conflict and when there is not a conflict. Because if I'm involved in both the employees' discussions as well as the employers' discussions, I can have a conflict because employee says something which comes and bites the employer, or the employer says something that could go and bite the employee. Where do I stand? I have to withdraw from representation. So when Department of Labor went and talked with individual employees, it's interesting. What they did was, they said, okay, here is your H-1B job description. And here are the 4 levels of wages. Entry level, level 1. Professional level, level 2. Technically advanced, level 3. And technical lead, level 4. Which level is your current job? And of course, employees would not know the context of this. Employees are trained to present their best resume. They'll invariably say, oh, I work at level 3 or level 4. I am a technical superviz. Next thing is the employer is getting into trouble because they're paying level 2 wages. I found that proceeding extremely unusual. I don't think Department of Labor will do it in all cases, but if it does, we need to be prepared to litigate something like that. That just is plain unfair. The way that information is presented and the way it's being used, that's just not acceptable. When the Department of Labor comes investigating, usually they are routine audits. They do give us notice, but practices can differ from region to region. I have pointed out non-routine elements in Department of Labor investigations already when they asked for all emails or they started interviewing employees about job descriptions and leveling. Okay, so the non-routine components can be hidden in a routine audit and investigation. And remember, Department of Labor audit adverse findings can lead us from 1 to 3 years of debarment from H1 and green card filings. That's a very severe consequence. USCIS ICE investigations. USCIS, as we know, typical issues are routine. ICE, except for the I-9, are almost always non-routine. Again, practices can differ from region to region. As I was telling you about the federal prosecutor acquaintance of mine, when I asked them, he did explain to me that a lot depends upon the way the U.S. Attorney's Office wants to work with the USCIS, ICE, other government agencies. So some of them want to be involved, especially in big cases. The U.S. Attorney's Office will get involved very early because they want to make sure the evidence gets prepared in the right way. State Department investigations are almost always non-routine. If KCC comes looking at your paperwork, please call somebody. Make sure that you don't treat this as a normal investigation. Department of Justice, typical issues are routine, employment-related discrimination, documentation discrimination. Tend to be routine, but not to be taken lightly because, again, you have the federal acquisition regulations, you've got debarment issues, so be careful with that as well. FBI goes without saying, almost never routine. The word almost is perhaps unnecessary. They are never routine. When FBI is involved, something is going on. FBI can seal our records, they can seize computers, seize bank accounts, seize assets. Our clients need to have business continuity plans. Okay. Limits of warrants are typically territorial. So the warrants are for one office. So if you have an off-site backup of your business records, unless they have a specific warrant for that site, they can't get that. At least you can continue in business because they'll come and take away all the servers, all the data, whatever is on the site. Your business is suffering. Another interesting thing I found out was that Miranda rights are not necessary. Miranda rights are necessary only if there is simultaneous arrest. So if they interview our client today, and again, if I'm wrong about this, please correct me. I'm not an expert in criminal jurisprudence, but I know enough to be careful. If they ask my client questions today without Mirandizing them, but arrest them 3 days later, it's okay. Again, FBI informal requests, gotta be careful with them. We had another case in which FBI came in. This turned out to be routine, actually, one of the exceptions, where a Pakistani-owned company, it was owned by people who were residents of the United States but citizens of Pakistan, and they had a lot of Pakistani employees. FBI came in and wanted to know the details of every person they had let go in the last 7 or 8 years and where they were. And this was a fairly lengthy affair. Quite frightening because it lasted so long. In the FBI, also, practices can differ from region to region. When they come, how they come, what kind of evidence they want. All this can differ. Be careful with interagency task forces. Whenever there's more than one agency involved, you've got to be careful. They are continually in flux. Agreements are formed, modified between agencies. If you look at any of the criminal indictments, you will see typically there's 6 or 7 agencies involved. IG's office, Department of Labor, USCIS, ICE, FBI. Um, so, whenever you have interagency task forces, I need to be careful. I just want to make sure that this is a routine matter or it's going to go away in a routine way. Um, Unfortunately, I only have about 3 or 4 minutes left in my time. Um, Let me see how much more I can do. I talked about fraud and misrepresentation. The definition under benefits is very, very vague. Government can throw out allegation of fraud without too many specifics. And somewhere along the line, they are going to lose a litigation on this. I'm quite sure of it, because um, the parameters of fraud are very poorly defined and the consequences are quite bad. They're quite severe. Um, as you have in the discussion that I just went over, do you have a right to review adverse evidence against you? How about FOIA, Freedom of Information Act? Problem is, when there's an ongoing investigation, government does not need to share anything with you. There are exceptions to FOIA. Of course, consular definition of fraud is quite interesting. If you go to Foreign Affairs Manual and look at fraud, there are some interesting spin-offs. And let me try to recollect. One of the ways they consider fraud to be something to be material is, oh yeah, this came up in an e-visa application we had. Um, Government alleged fraud about something, and our client, who was a very respectable businessman, had definitely not considered his question, his answer, and gave an answer offhand because he had earlier submitted the same information to the government. So when the consular officer tried to create a fraud case out of it, we were able to point out that under FAM, Foreign Affairs Manual, if there's actually, I think it's a lawsuit, it's a district court case where it says that uh, if government already has that information, I think it's a part of FAM now, if government already has the information, then even if somebody slipped up in giving that information the second time around, it cannot be considered to be fraudulent because government already had that information. Matter of Lozada, this half-page decision, has become a problem as well as a solution to many problems for many of us. I want to talk about matter of Lozada very, very briefly. What if you run into a situation where you you find that either the lawyer had done something wrong or misadvised? How do you deal with that situation? Well, of course, your first loyalty, my first loyalty, is to the client. It is very painful to go against a member of the bar, but we have no choice under certain circumstances. Okay, so matter of Lozada needs to be studied. How to file a complaint for ineffective assistance of counsel, because it protects your client. And often the bar complaints, etc., do not amount to much because lawyers will have an explanation. Um, but it is important for us to protect our clients. We had a case in which a New Jersey law firm refused to share information with their own client. They filed an RFE response in an H-1B case, and when we asked for the information and the employer asked for the information, the law firm refused to share the information. In other words, we are not allowed to see what they have filed on our own behalf. What do you do in those cases? Of course you file a complaint. Of course, we were able to get the documentation through Freedom of Information Act request as well. Then there's the problem of dual representation. Like I was telling you, in the Department of Labor investigations, who do you represent? Whom do you represent? Is it the corporation? Is it the employee who's being questioned, or is it the individual officer? Okay. And very briefly, last comment is acting as an expert witness in issues which are arising from our own filings is generally a really bad idea. because of credibility issues, conflict of interest with clients, dual representation conflicts, and being a fact witness if you are also the lawyer in the case. So if I'm invited to be an expert witness in my own cases, I typically decline, because tomorrow my own competence or my own filings, or not tomorrow, but in that proceeding, they'll be in question. How do I deal with that? From a witness stand, as a fact witness for the parties, or do I deal with it as an expert, which should be somebody who's isolated from the proceedings? So these are some of the other issues that come up. I did not have time to invite a lot of input. I apologize for that. I didn't think it was going to take this much time, but hopefully we can do it offline.